Okay, good morning, everybody. I'm Byron, South Carolina Association of Realtors, General Counsel. We're located in Columbia, South Carolina, near the intersection of Interstates 26 and 20. If you're ever in the area, please stop by. We do legal issues and lobbying issues for South Carolina realtor members. So my background, I've been here quite a while. We handle the Standard Forms Committee. We do professional standards, ethics, and arbitration across South Carolina. We have a legal action committee that's handling a $250,000 arbitration lawsuit in some kind of court with right now, and a short-term rental ban in the upstate of South Carolina. Like I said, we do mediation, professional standards committee, grievance committee. That's kind of what and we do the legal hotline. So you can contact us anytime on the legal hotline. The phone number here is 803-772-5206. My direct line is 803-824-1971. You can reach out with forms questions at any time, ethics questions at any time, general real estate law questions at any time. And our emails, you can reach us by email as well. It's always our first name at screaltors.org. So mine is Byron at screaltors.org. We have two other attorneys here. The CEO, Nick Midas, is Nick at screaltors.org. And Austin Smallwood, Director of Legal and Legislative Affairs, is Austin at screaltors.org. So kind of some top three things that are going on, just to make you aware. The coronavirus, the COVID-19. A little bit of good news. I reached out to Washington State, their legal department. They're not hearing any real estate realtor market issues coming from the virus out in Washington State. And I noticed you guys were looking at zip forms when I first logged on. We anticipate meeting or renewing the benefit for zip forms for another year, 2022. The other thing that we've been heavily promoting is fair housing. If you haven't seen the Newsday article out of Long Island, New York, after this call, sometimes later this week, going to Google, put Newsday, which is a news organization, Newsday, Fair Housing, Long Island. This Newsday news organization did an extensive undercover videos and audio on real estate agents in Long Island. Testers, Asians, African Americans, Latino Americans, and found some sort of disturbing steering going on in certain neighborhoods, and the realtors are on camera, hidden camera, saying some pretty disturbing things about fair housing. So please keep that in mind, and just treat everybody the same, and follow the code of ethics. Main issue. So our forms committee is 10 realtors, made up of a realtor from each region of South Carolina. They're all brokers with 3 at-large members. And they meet periodically. Right now they're working on updating the listing agreement for the MLSs that are adopting the clear cooperation policy, which is the new policy to kind of curb some of the coming soon abuses. Basically, you can have office exclusives, but if you publicly market on Facebook or media, electronic media signage, any kind of public marketing, it would trigger the 1 business day to get the listing into the MLS. But also exclusives that are not publicly marketed would still be allowed. And so we license the SCR forms to zip forms, obviously, DocuSign, Loop, and Internet long form. That's kind of what our forms committee does and where our forms are licensed right now. And we certainly take form suggestions year round. You can email me or Byron at screaltors.org or call us anytime with form suggestions. So the primary thing that the forms committee was working on in 2010, the forms were updated, kind of the version that you're seeing now basically came out of the 2010, 2011 forms committee. So it's been in operation basically across South Carolina. We borrowed heavily when we saw North Carolina went through due diligence. Nick and I first saw due diligence in North Carolina. We felt like that was very good form. It was genius. It solved our 2 biggest problems. Our 2 main hotline calls back in the 2010-2012 era were earnest money disputes and repair procedures. Basically, the deal falls apart. Buyers and sellers won't sign the SCR 518 release to release the earnest money and disperse it. And so that means the broker has to hold the money indefinitely unless the broker decides to take the buyer and seller to the magistrate to complete a court. Or one of the parties hires the contract. So repair procedure, there was constant arguments about repair procedure has 9 basic categories of repairs. You're basically getting a basic working house. So people argue about if a certain repair fit into one of those pigeonholes or not. So due diligence cured both of those. So North Carolina had been using due diligence for a number of years. And so the Forms Committee adopted basically a due diligence addendum about circa 2012. So from 2012 until today, we've had due diligence. But we also had a repair procedure track. So in 2009, if you weren't aware, there was a broker shot in Fort Mill. There was a $1,000 earnest money dispute. The enraged buyer was in a magistrate interpleader case that got continued, and the enraged buyer went into the brokerage office with a pistol, pointed it at agents in the office, went to the broker's room and shot the broker in the abdomen. Thankfully, the broker survived, but at that point, Forms Committee wanted to put some language in the contract to be able to disperse the earnest money without these long, drawn-out disputes, these court battles over earnest money, especially small amounts of earnest money, $500 or $1,000. So about 2012, we put in the disbursement triggers. So if you've been around since then, you probably have seen those disbursement triggers that used to say if you try to get financing, that failed, you got your earnest money back. Every contingency basically that didn't work out, the buyer got their earnest money back, and there was even a fail-safe 30 days after a failed closing. The escrow agent would disperse the money to the buyer unless the seller filed a lawsuit. So it kind of got the brokers out of the loop on these disputes. It was fair to the seller had time to sue if they wanted to. So my calls on earnest money went from my #1 problem call in 2012 basically to zero. 2012, 2013, 2014, 2015, 2016, 2017. 2016, 2017, there was a dispute in Charleston. The $1,000 is finance contingency. They didn't get their loans. The broker dispersed for the finance contingency. The seller didn't like it, took it to magistrate court. The magistrate read the contract, so the broker did what they were supposed to do. So the broker prevailed. Seller was still angry and filed a complaint with the Real Estate Commission. So we backed the broker at the Real Estate Commission, took about $8,000 about a year, and we won the case. And we felt like that's the test case. This issue settled. We can use these triggers to avoid earnest money disputes. But the Real Estate Commissioner is almost immediately, we're at our conference in Greenville in September of 2017, and said, we're just going to keep going after brokers on earnest money. We don't like brokers dispersing without a release or a court order. And so at that point, our leadership to take all the triggers out. So all the disbursement triggers have been removed. So my hotline calls on earnest money it's now the #1 call again, just like it was pre-2012. So a lot of brokers, to avoid this dispute, are using attorneys to hold earnest money. The attorneys seem to be happy to do that because it enables them to get some business, hopefully get the closing business by holding money. And so the lawyers are not under the Real Estate Commission regulations. The lawyers can disperse how they see fit. So what I would recommend is use a lawyer to hold the earnest money, have the lawyer draft an escrow agreement. The lawyer signs the escrow agreement, the buyer signs the escrow agreement, the seller signs the escrow agreement, roughly the time of contract formation and the money's deposited. And I would recommend there be basically another fail-safe in that escrow agreement that basically says 30 days after a failed closing, this money is going back. The parties agree the escrow agent's dispersing this money to the buyers unless the sellers file a lawsuit. That way, these disputes, because now I'm getting calls from lawyers that don't know how to get the money out of their trust account. They don't have escrow agreements. So with an escrow agreement, most lawyers can disperse without having to go to court. And it protects the seller a little bit because the seller still has 30 days or it could be 60 days, whatever the parties agree upon, to hire a lawyer and sue the buyer for breach of contract. So, and Tiffany had sent me a bunch of your questions. The first question was about earnest money acknowledgement. I can do that. Sure, I can talk louder. So this is Form 310. So a lot of the questions, the first question that Tiffany sent me was about earnest money. So earnest money is handled in the contract under Section 5. So basically, the way this works is it's designed, it'll say Section 5 total. So we'll use the usual example. Total of $1,000 earnest money is paid as follows. Either $1,000 accompanies this offer, or say the seller, forgot their checkbook. You could say $1,000 will be paid by 6 p.m. You put a calendar date. So another tactic that you can use to avoid earnest money disputes is make the earnest money bill payable after due diligence. So you can make your due diligence, say April 1st, 2020. You can make the earnest money due, April 5th, 2020. That way, if the buyer were to terminate under due diligence, you would never even get to the point of depositing the earnest money. And then we already talked about trying to get earnest money, an escrow agreement with the attorney. So the escrow agent acknowledgement, typically there's a lot of complaints about page 8 of the contract. It was the one page with, you filled a lot of informational blanks. Realtors don't like filling in blanks. There's a lot of complaints about it. So some of that page 8 was moved to other parts of the contract. And this is an example. There was a signature blank for the escrow agent, because that was typically the buyer brokerage, right? So typically the buyer broker, when they're writing the offer, would go ahead and authorize their buyer agent to sign the contract saying, hey, we're going to hold the earnest money. But what we're seeing is, because the earnest money disbursement language was removed from the contract in 2017, a lot of brokerages are now using attorneys to hold the escrow, and it's difficult to get the attorney to sign if you're writing the offer. To drive over to their office and give the sign, just probably more problems than it's worth. So in the contract, it has a sentence to the second sentence, buyer and seller authorize, Byron King Esquire as escrow agent to deposit and hold dispersed earnest money according to the terms of any separate escrow agreement. So this is the one I would recommend. You always get the attorney to draft an escrow agreement, and everybody signs it when the lawyer takes the money. And put a fail safe in there where it says, 30 days, 45 days, whatever the parties agree upon. Parties agree the escrow agent's going to disperse the $1,000 to the buyers unless the sellers have filed a lawsuit regarding the earnest money. The law and any regulations. Broker does not guarantee payment of a check or checks except as earnest money. Parties direct escrow agent to communicate reasonable information concerning confirming receipt, status of earnest money upon a broker request. This is where you got to ask, hey, did you get the money? Did the check bounce? Sort of questions. Earnest money is not delivered by the agreed upon date above. And this basically reiterates kind of contract law. If you obviously do a breach, the seller may terminate by delivering notice of termination to the buyer. So this next section is basically language we put in there to basically help you make the parties understand the deal falls apart, the earnest money is caught up in some sort of dispute, especially if a broker's holding it. That money may be locked down for a long period of time until the parties sign some sort of disbursement agreement. So it basically says the parties understand and agree that under all circumstances, including default, escrow agent will not disperse earnest money deposit to either party until both parties have executed an agreement, which would be the escrow agreement authorizing the disbursement. And there's some examples. SCR 518 is the release plus disbursement. 517 is a rarely used form. That's a disbursement only. We had a situation where there was some seller that wanted to sue the buyer but was willing to release the earnest money. That almost never happens, but we didn't have a form, so we created one. So 518 is the primary form. I think that was one of the questions Tiffany sent me. Mediation agreements, obviously the parties can mediate. Settlement. Mediation settlement, we have mediators, realtors that are trained in mediation. The buyers and sellers would talk to each other and figure out who to hire as a mediator, where and when to meet. And the mediator is not a judge, so the mediator just keeps the peace until the parties figure out a way they want to split the money. They write that down, sign it, and then move on with their lives. Or until a court of competent jurisdiction has directed disbursement. So we use that language because if it's greater than $7,500, you're in circuit court, which typically needs a lawyer, and it takes a long time to get into court. less than $7,500. Only if the broker in charge is holding the earnest money, a broker in charge could volunteer to sue the buyers and sellers in a magistrate interpleader lawsuit. Earnest money will not be dispersed until determined to be good funds. That's to prevent a broker from getting a bad check. Trust accounting is wrecked. You would have to come up with your own funds or potentially face some discipline. If legal actions occur related to earnest money, party receiving the least amount of earnest money in the court's disbursement order agrees to indemnify the escrow agent's fees, court costs, and attorney's fees. This is in here to try to force parties to settle, especially on $1,000 or $500. There is no economically feasible way to disperse that earnest money. So basically the broker could basically scare the parties into settling. Say, look, if you guys drag us into court, the loser is going to pay all my attorney's fees, which could be pretty expensive. If interpleaders to be utilized, the parties agree that fill in the blank number of dollars shall be paid to the escrow agent by the parties as compensation for the escrow agent initiates court of competent jurisdiction proceedings on earnest money. So that's in there to, again, force the parties to settle. So if it's $1,000, you could put, hey, you're going to pay me $1,000 or $500, so before I'm even going to file an interpleader, that way the parties would say, look, we got to pay you $500, the same amount of money to the broker. We might as well figure out a way to split this money up and move on with our lives. So that's kind of the earnest money section. Any questions while we're in this section? So what are your agents typically doing? Is the brokerage holding the money or a law firm? And then when the attorney's holding, are you guys getting escrow agreements? Yeah, it's a little disturbing. So make sure if you're using attorneys, say, hey, let's get an escrow agreement. It's only a 1 or 2 page document. It'll save everybody a whole lot of heartache in the future. Because now I'm getting calls from attorneys that say, Byron, I got a dispute and the contract doesn't say how to disperse the money. So I tell that story like I just did about the real estate commission, tell them why it's not in the contract. And then they go, well, what do I do? Well, that's up to you. It's kind of basically implying it's your problem, not mine. But an escrow agreement, I would never take, if I was a closing attorney, I would never take somebody's money without an escrow agreement, without basically a fail safe to get that money out of my account. Otherwise, the attorneys are having to sue people in circuit court in an interpleader action. Yeah, so if you're using attorneys, you probably want to make sure you get comfortable with the attorneys. Maybe have some of them on speed dial. Maybe have some escrow agreements, copies in your briefcase, and asking the attorneys if they want you to put a dollar amount in there. So if the brokerage, you could obviously tell your agents, hey, I want. Because the other problem is we had some large brokerages where the broker said, look, I'd love to file a magistrate interpleader, but I'll have 7 or 8 of these a month. I can't spend 7 or 8 days for free sitting in the magistrate court. Filing costs are $100. The time to fill out the paperwork's got a value. I'd be happy to do it if they pay me X amount of dollars. So between that and forcing the parties to settle, the better, especially if the brokerage is holding it. So if the amount is equal to the earnest money or the amount exceeds the earnest money, that's obviously going to give financial incentive to the parties to try to work something out rather than getting angry at the brokerage for not filing the magistrate interpleader. Remember, the magistrate interpleader is why the enraged buyer showed up at the brokerage with a pistol in Fort Mill and shot the broker in charge in the stomach. So you want to try to avoid earnest money disputes if at all possible. Right, and then to help you, we also have a Form 620 earnest money disclosure. So this basically reiterates what we just talked about. It just or President-elect said, hey, Byron, I know it's in the contract, but it's a whole lot easier to simmer somebody down when they're upset about me holding earnest money when I can, you know, because you pull out the contract, they're like, look, I just initialed everything. I didn't read any of that. But if you can pull out a one-pager with their signature on it, it makes it a whole lot easier to calm them down. So that's the value of this Form 620, the earnest money disclosure. It just basically reiterates what we just talked about. Broker in charge holding the money has to hold it in accordance with South Carolina real estate license laws. It says buyers and sellers agree if a transaction fails to close, a broker in charge acting as escrow agent shall hold the money in safekeeping in accordance with South Carolina laws and shall not disperse the earnest money until everybody signs a disbursement agreement. Typically that's Form SCR 518. We'll pull that up here in a second, or it would go into court. And only when parties sign a disbursement agreement or disbursement order is obtained from the court, the broker in charge will properly disperse the earnest money within a reasonable amount of time in accordance with South Carolina laws. And here's the part we're talking about with the lawyers. If parties are using a lawyer to hold earnest money, parties should consider signing a written escrow agreement with that lawyer that details how the earnest money is held and how the money is dispersed by the lawyer. Parties can sign that. And so we're talking about 518. That's the release plus disbursement. So this is a good form because it basically says nobody's going to sue anybody, and here's where the earnest money is going. So it basically says this release is entered in as of this date between the buyers and sellers and third-party beneficiary brokers. For that contract covering the property, and becomes effective as soon as the party places the final required signatures and or initials on this release and delivers notice to cause this release to be binding on all parties. So deliver notice, the SCR contract, the forms committee was concerned about forms getting lost in the mail, forms getting lost in email filters, fax machines eating documents. So the way the forms try to work is they require delivering the electronic or paper document to the notice address, which is typically the agent's fax number, the agent's email, or the agent's office address. And there has to be knowing receipt to prevent, the fax machine eating the document, the front desk losing the document. So when you deliver, best thing to do is if you're emailing it, you get on the phone, talk to a human being, the other agent in the transaction, say, look, I just sent you whatever document you just sent, I just emailed it, check your inbox. And so once you've done that, hopefully that will create, you'll be aware of the receipt. And so you basically describe the property, and then it says, each of the signees here too in consideration of each other, the signees releasing the other signees from the contract, you hereby release each of the other parties, brokers, and escrow agents of the contract from any and all claims, losses, costs, damages, expenses, actions, demands whatsoever with each of the parties and brokers hereto may have had up to this date against any of the other parties or broker hereto by reason of the contract. It talks about is the intention of this release that any responsibility or obligations or rights by virtue of the contract by this release are declared null and void and no further force or effect. And then it says the escrow agent holding earnest money or other deposits on the contract is hereby directed forthwith to disperse said earnest money and other deposits in the following manner. This is where you would, for your typical $1,000 earnest money, $500 to the sellers, $500 to the buyers, for an example. This is a legally binding release executed voluntarily and solely based on contract representation. Signee solely responsible for obtaining legal counsel prior to signing and the knowledge they've had ample time for counsel. Buyers and sellers and brokers would sign it. Like I said, this is Form 518. That was one of the questions that Tiffany had sent me. What was the best way to end a contract? This Form 518 is the ideal form to use for that. I got a little feedback. What was the question again, Tiffany? Okay, understood. All right, so let's go back to the contract. So notice of termination is a loaded gun. Only use it if the buyer is timely and properly terminating under due diligence. So Section 8 has a repair procedure checkbox, or you can select due diligence. My recommendation would be to always select due diligence. That cures basically any problem almost I've ever gotten on the legal hotline. So being from your market, you're very familiar with the North Carolina due diligence. So this would be a way to make the forms work consistently on both sides of the state line. So due diligence, the question is about Form 313. So the way this due diligence works is you have a due diligence period begins on the effective date, expires at 6 p.m. on April 1st, 2020, whatever date the parties agree upon. During the due diligence period, the parties can basically inspect, look at the property, look at off-site conditions, on-site conditions, other properties, etc. During the due diligence period, the buyer can basically do these 5 things. They can conduct inspections of on and off-site issues. They can deliver the repair request, and they can also proceed with the contract with the amendments for the repair procedure, which is 525. Or they can basically buy it anyway. This is in there in case, say, the seller has a backup buyer at a higher price, but this is the buyer one's dream home. They can't agree to amend the contract with the repair procedure, SCR 525. The buyer could still say, it's my dream house, I'm going to buy it basically as is. I'm not going to sell it to somebody else. And then number 5, during the due diligence period, the buyer can terminate the contract by timely and properly delivering the notice of termination and termination fee within the due diligence period. So this notice of termination, this is the only time you should be using 313 without the party getting legal counsel. This notice of termination 313, we're about to pull up here, very dangerous form. It's a loaded gun. If misused, it could get you sued, facing ethics and license law complaints, could get the buyer sued, could get the seller sued if it's used on the seller side improperly. So best thing to do, notice of termination is SCR 313 should only be used under due diligence during the due diligence period, unless you've told the party to obtain legal counsel prior to using it. So let's look at 313. So notice of termination, very dangerous form. Just think of this as a loaded gun. It should only be used comfortably during the due diligence period, because this will get you sued. This will get your client sued. This will get you facing ethics and license law complaints in a heartbeat if misused. So just remember, notice of termination, it's form 313. Should only be used during the due diligence period comfortably, unless you're telling the parties to obtain legal counsel. If they want to ignore your advice, that you warning them to obtain legal counsel, be your get out of jail, get out of ethics jail, get out of license law jail, get out of lawsuit defendant. You say, look, I warned them to obtain legal counsel in this form. They want to use it anyway. So it's basically, you describe the parties and the property. And then notice and delivery is this thing we talked about briefly, where you got to deliver a paper, an electronic document from one party to the other. Notice for one, if you give notice to the broker, which is everybody working at that brokerage, that's deemed a notice to their party. All notice, consents, approvals, counterparts, similar actions on the contract must be in paper, electronic writing, and will be as effective as of delivery to the notice address, notice email, notice fax in the contract. Critical awareness of receipt by the broker, unless the parties agree otherwise. Notice what's not in notice. Text number. So do not use text to negotiate contracts. Do not use text to deliver notice and delivery. You can only use documents sent to a notice address, a notice email, or a notice fax. Those are listed on the signature page of Form 310, the contract. So you got the notice address, email, fax. Notice the text number is not in that list, so do not use text. This would be for the buyer. So typically I would anticipate on the buyer side, the notice address is going to be the buyer agent's office address probably. The email is probably going to be the buyer agent's email. Fax number is typically going to be the buyer agent's brokerage fax number. And there is no text number, so do not use text. On the seller side, mirror image, typically going to be the listing agent's office address, the listing agent's email address, and the listing agent's office fax number. Typically, notice there is no text number there, so do not use text. The hotline gets a lot of calls where people are negotiating contracts, trying to do all sorts of things with text. So the way the Forms Committee tried to eliminate text, because they're informal, they will get you sued, they will get you under an ethics and license law violation. The Forms Committee did not put text numbers into that list. So we're talking about the office address, we're talking about the realtor's email address, we're talking about the brokerage's fax number primarily. So 33, right? Right. So remember, my recommendation is to use due diligence. Staff tried to get an all due diligence contract like North Carolina, and there's been some resistance from the members. They wanted this repair procedure. Just be aware, repair procedure is the second highest call that we get behind earnest money. So repair procedure, you have to kind of educate buyers. Say, look, we do have a repair procedure. You know, I'd recommend you use due diligence, because under due diligence, you can negotiate much wider. The solutions are much wider. Repair procedure is a very limited procedure. It's basically designed to help a buyer basically get sort of a working operating house that works in a basic manner. And the buyer cannot walk away. The buyer is in the contract, except for a very small window that usually is disputed if the window even exists. So repair procedure, not the ideal, but we'll go through it. So we say you want to use repair procedure. So the first section talks about this is basically the buyer's duties. So under repair procedure, inspections and requests shall be completed and delivered to the seller by 6 p.m. on right in the calendar date, April 1st, 2020. So if you remember, the old form had business days, which were, you know, the downside of business days is they're hard to count, right? So this form is a lot simpler. However, the reason business days were in there was for a very specific reason. If contract negotiations go on for a while, business days automatically push all these deadlines. That's not the case now. So if you put in April 1st, 2020, and then you get into 2 weeks of contract negotiations, and you don't update this date with initials and, you know, changing it to a different date, April 15th, 2020, with initials and date from everybody, buyer's going to be in a fine. So pros of writing in the calendar date, it's easy. The cons are, if negotiations take a while, you need to make sure you're updating them. Moving on, any and all requests necessary to place the heating systems, air conditioning systems, electrical systems, plumbing systems, water supply systems, wastewater systems to be conveyed in operative condition. And lawyers love to argue about what operative condition means. Make the roof free of leaks, not to replace the roof. Not to replace a worn roof, but to make, if it's not leaking, it's the roof conveys. Address environmental concerns, which typically maybe some sort of mold issues or radon issues. And then lawyers love to argue about what address means. And the one that everybody loves to argue about, make the improvement structurally sound. So that's one that everybody argues about. So you can see there's a lot of arguments. There's enough language for a judge to make a decision, but obviously nobody's going to take a repair procedure far enough into the South Carolina court system to create case law. Even if they did, most houses are different. Lawyers could differentiate the case law anyway. So this is just lawyer time for this one if there's any kind of disputes. It should be delivered by the deadline above. If the buyer fails to notify the seller within this time frame, buyer has waived any all rights in this section. Basically, these are our fail-safe language. If the buyer snoozes through their deadline, they lose all their rights to ask for repairs. If lender's commitment requires any additional inspections or certification, those are to be provided by the buyer. Buyers and buyer's expense shall have the privilege and responsibility for inspecting the structure, square footage, environmental concerns, including but not limited to mold, radon, gas, lead-based hazards, including lead-based paints, wetland study, and appurtenant buildings, heating systems, air conditioning systems, electrical systems, plumbing systems, water supply systems, wastewater systems as well. Pertinent equipment and appliances. Upon seller's request, the buyer will provide a copy of the inspection report. So the first paragraph is what the buyer's got to do. The buyer's got to get their inspections done in a timely manner. If they snooze, they lose. And then it basically says, no later than 6 p.m. on a calendar date, the seller shall deliver notice agreeing or not agreeing to make the repairs on the buyer's repair request. So you would use a Form 525 repair addendum, and up here it basically says when you have to get it completed and delivered to the seller, 6 p.m. on, fill in the date. So you're always going to have a date here, say April 1st. This would always be a later date in the second blank. So obviously, because you want to give the seller enough time to get their repair request done. So you would want to get your inspections there, and then you would want to give, depending on your market, if it takes 2 days, 5 days, 6 days, 10 days for contractors to get out there. And you don't want to overload the seller on these repair requests. This is not just a wish list. This should be limited to basic repairs that are, obvious from the inspection reports. They're not paint the den, they're not replace the worn roof. They're not only cosmetic issues. Then it talks about the cost to make the house basically operating under this list that mimics the above list, or to be paid by the seller. Seller paid requests do not include home maintenance, flooring, fog window, grandfather code issues, landscaping, preventive maintenance, cosmetic changes, home improvement, and energy efficiency. Note, if the seller says, I'll make all the repairs, you're in the contract. Unlike due diligence, where the buyer could, say, look, I found something I like better, or I'm not comfortable with, foundation repair, $50,000 of foundation repairs. Under repair procedure, too bad, buyer, you're in the contract. The seller says they're going to fix it. You're locked into the contract. Sure, go ahead. So if you're getting, right, so I know that's a common thing to do. I would recommend you're using due diligence if you're using creative solutions like that, because note, there's nothing in here about cash for repairs. So if the seller said, I'll give you cash in lieu, the buyer could say, look, I've got a window of 2 calendar days. You didn't agree to make the repairs. I'm terminating.
And it's 2 days from the time the seller comes back and responds, whether it's verbally or in writing, correct?
So it says if the seller does not timely, yeah, in essence, yes. If the seller does not timely respond or does not agree to make all the seller paid repairs. So that could be, if the seller didn't send anything by their deadline, they didn't respond, did not timely respond, or they do not agree. I would be nervous about verbal because people can change their story. So what I would do if somebody tries to verbally say, I'm not going to make the repairs, immediately send an email back saying, hey, listing agent, I enjoyed our conversation. This memorializes our conversation where you verbally told me the seller is not going to make the repairs. And that way you've got some documentation. So you want to always try to document anything, especially some sort of verbal comment like that. Ideally, you would get an email from the list agent saying, seller refuses to make all the repairs or refuses to make, repair A, B, or C. Now, keep in mind, if the buyer replaced the worn roof and the seller says no, the buyer's still in contract because that's not one of the basic repairs. Only if the roof is leaking and the buyer says fix that leak and the seller says I'll fix that leak, you're in contract. Only if the seller either didn't respond in a timely manner or said I'm not fixing that roof leak, does the buyer then in the third paragraph have their 2 calendar days to, hey, it's my dream house, I'm going to buy it anyway, or hey, would you guys negotiate maybe if I raise the price $5,000, would you put a new roof on it, basically financing the new roof. or they could terminate. So, but if the buyer wants out, probably best not to get into some sort of negotiations. Just go ahead, terminate, and then go back and negotiate.
Let's say it's at 6 p.m. on March 12th, but the seller comes back on March 10th. It's not March 12th that you have the time frame, so it's March 10th that you want to calendar from.
Correct. So that's this sentence, this phrase right here does not agree to make all the seller paid repairs. So, so say your deadline for the seller to respond was March 12th, like your example, and the seller came back on March 10th and said, I'm not going to make those, I'm not going to fix that leaking roof on March 10th. That triggers your 2 calendar days. A little bit with it. Say it again, please. So calendar days are, you look at the dictionary. So today is the 11th. So within 2 calendar days of March 11th, that would be calendar day 1 would be March 12th. Calendar day 13 would be calendar day number 2. So calendar days run midnight to midnight, but remember, you've got to be able to deliver documents. They've got to receive them. So don't be doing stuff when people are asleep. Do this within business hours would be ideal, because remember, under notice and delivery, you've got to deliver the notice of, the 518, or you're going to terminate using 313 after you've warned the buyer to talk to legal counsel. You've got to deliver that 313 to the other side, to their notice fax machine, their notice email, or their notice office address, and they've got to know they received it. So if people are in bed asleep and their office is closed, your buyer might miss that deadline. So say you waited till March 13th on Friday the 13th, not a good day. You send it over at 11 p.m. They don't get it to the next morning. Seller's lawyer then argued to say, you didn't make delivery for the contract. We didn't receive it, so it didn't have any effect. You're out of your deadline. Your buyer is now in an as-is contract. Your buyer gets upset. Your buyer sues you, files ethics complaints against you, files license law complaints against you because you tried to send something 11 o'clock at night. It caused them to get into a lawsuit with the seller. So calendar day. Right. So due diligence is the recommended thing to use. You're in near North Carolina market area, so you're familiar with due diligence. So it operates pretty much the same, except the fee is due on the back end of South Carolina. They were concerned about Forms Committee was looking at North Carolina. They were concerned because North Carolina, you pay the due diligence termination option fee up front. So say you paid $1,000 to the seller. The seller's a bad guy, and they're just doing it to collect money and kill deals. I'm not making any repairs, blah, blah, and keeping the money. But South Carolina Forms Committee felt that could be unfair. And they didn't like paying money up front to get out of the contract. They didn't like the philosophy of that. So the South Carolina termination fee is paid only if the buyer terminates. You never pay that money if the buyer buys the house. So the due diligence period begins on the effective date and expires at 6 p.m. on, fill in the date. If you had March 13th, for example, keeping consistent with what we're using, Friday the 13th, you would have to send them the 313 notice of termination plus the $100 of termination fee. You would get your car probably and drive over to the listing brokerage's office, walk in and physically hand it to a human, maybe even videotape handing it to them, get a receipt so you've got documentation of this time. Yeah, so never go up against deadlines because you're just inviting problems, because all these deadlines, if you miss on this thing, basically turns into an as-is contract. I don't have perfect statistics, but just basically going around talking to realtors at, basically meetings like this, I would say, I call it like an urban legend or urban myth that due diligence is bad for the seller. So I try to convert people to have an open mind about due diligence because it was new in 2012 and there's still kind of a street prejudice against it, in my opinion. But I try to tell people, look, due diligence is good for the seller because buyers think they can walk anyway. They think they can do it anyway. At least this puts some cash in the seller's pocket. And if a buyer's not going to buy your house, at least under due diligence, you'd probably know by the deadline instead of them waiting to trying to find a loophole to get out of the contract or just not showing up on the closing day. So there's some advantages to due diligence even for the seller, but I would say most realtors in South Carolina, that it's still kind of an urban myth that due diligence is buyer friendly. Even though I disagree, but we did have a large, Charleston was kind of the leader on this. Our membership in South Carolina is 50% of our members on the coast. Most of them are in Charleston, followed by Myrtle Beach. So 2011 Forms Chair was a Myrtle Beach person. 2012 Forms Chair was from Charleston. And like I said, we originally had a due diligence contract, but Myrtle Beach resisted it because they were scared to death that snowbirds weren't going to buy any more houses in Myrtle Beach, even though we said, look, North Carolina is all due diligence. They have coastal property selling. It hasn't created turmoil on their market. But because we had so many members in Myrtle Beach that resisted due diligence, the compromise was to basically leave repair procedure and due diligence and let the parties choose, which probably gives more choice. It's probably a better thing in the long run. But my point from getting to that was in Charleston, there's a brokerage with a large amount of market share, and they ran the numbers on fallout on residential deals that failed to close, which was their more or less repair procedure due diligence. What they found, it was basically even. The ones that didn't close, half were repair procedure, half were due diligence. So it was not, the due diligence was not the deal killer that maybe people feared in South Carolina, and obviously North Carolina. You guys are comfortable with due diligence, been using it for a long time. Greenville adopted our state forms in 2016. Part of that, they had free due diligence. It was basically 10 days, basically kick the tires. But even up there, there's resistance to it. And well, they didn't call theirs due diligence. It was basically some sort of inspection period. But it was basically free due diligence for 10 days. Even up there, there's I run into resistance to it. So, but I don't have perfect statistics on it. What's kind of your agents, they seeing? What kind of usage are your agents seeing?
We're seeing it more and more, but it took a long time to get to see the due diligence community, and certainly I don't think that we can do quite yet.
Right.
What I see. On due diligence, another difference between North Carolina and South Carolina is agency is.
Right, good point. So, like I said, our 2010 Forms Committee looked at North Carolina's and talked about they didn't like paying the fee up front, but they also wanted due diligence to be short. They wanted this due diligence period effective date 6 p.m. on date. They wanted that to be like the 10 to 15 days after the contract was set up. And if financing is in due diligence is going to be longer, right? That's what you guys probably see in North Carolina. So 3 things were put outside of due diligence: finance, and these were all to make due diligence period short, make due diligence focused on the inspections and repairs rather than just this because the fear was, hey, buyers might get cold feet and walk. So the idea was to make it shorter. That would help the seller. The seller would know if a buyer wasn't going to buy their house, they would know it in that 10 to 15 days after the contract was established. So you could make it work like North Carolina because you can always check box not contingent on financing. Then it works just like North Carolina, but then you probably want your due diligence period to be a little bit longer so you can get your financing set up. But if you check it is contingent on finance, this contingency runs to closing, but it allows you to have a shorter due diligence period. There was 2 other areas that were outside of due diligence. One was appraised value. The idea of the forms committee was, and again, you can make it work like North Carolina. You could check this contract is not contingent upon the appraised value. Then it works just like North Carolina. But if you're to check box, this contract is contingent on the appraisal. The idea being due diligence would be on getting the inspections done. And then if you walk, you could basically save, $500 to $800 on appraisal is the idea. So the idea was most people do the inspections, then they order the appraisal. So the appraisal has the ability to be outside. The other issue we ran into was in South Carolina, basically the termite letter. The termite letter by government regulations has to be within 30 days of the closing date to not be stale, to be active. This is a term. So, and again, you can make it work like North Carolina. You can say it's not contingent, and then it works just like North Carolina. But if you say it's contingent, it's basically a miniature repair procedure. It's designed to work on the back end. So you'd have your due diligence, say, done in the first 10 days after contract. And then say the close date was 4 months from now. It's a long closing date to get the CO 100, the wood infestation report, aka the termite letter, to be dated within 30 calendar days of the closing. That's why this is outside. So finance, appraisal, and wood infestation report can operate outside of due diligence. Or they could operate like North Carolina. You just check not contingent finance, not contingent appraisal, not contingent CO 100, but that's going to make your due diligence period long.
Thank you. Another question, not related to that, page 1. It's where you're checking that you provide the disclosure. I actually had one of the large brokerages and they told me they basically last week I said, well, I listened to video from the Counsel office and so I went back to the video and I identified the answer. But some people are thinking that if you're not being licensed, or licensed South Carolina real estate licensing, you don't have to check your relationship boxes or initial them below. And I directed them to your video to listen to her, and they were surprised, but they're the brokers were being told otherwise. So can you clarify for our brokers this section?
Yeah, short answer is you're correct. Kind of the long answer. And again, this goes back, remember the old page 8 where you had all those blanks and realtors hated filling out that last page. Forms committee decided to move it around the contract, basically kind of trick the realtors into not realizing all the information still in the contract in some sense. But at any rate, so these are both from license laws. So that other brokerage, if they're doing that, every time they've done that, it's a license law violation with absolutely no defense. So license law says, upon substantive contact, basically thou shalt go over the South Carolina disclosure of brokerage relationship forms. So my recommendation would be to print a bunch of those South Carolina disclosure of broker relationships form and to let you know what it is. It's the form 110. Pull up, my password expired, I guess, but so there's 2 license laws. So license law basically says thou shalt, if you're, if a realtor or real estate licensee is a buyer or seller, thou shalt disclose it on page 1 of the contract in bolded, all caps, underlined language. So these are 2 sections of license law, and I'll let the forms committee know. Maybe it's confusing. Maybe they can move them around so it's more obvious that you're correct. So the part I've highlighted basically said, and this would only be used if the realtor, real estate licensee is the buyer or the seller. That's the only time you use this. So that's one portion of license law. This other part used to be on page 8. In a sense, it was camouflaged because you didn't have to check box, but you were check boxing. I'm the buyer agent. You were check boxing. I'm the listing agent, which did the same thing. So license law basically says, thou shalt in the contract get the consumer to acknowledge if they got client or customer service in this transaction. So there's 2 portions of license law that are completely separate, because they're close to each other on the contract and the layout. I can see how that might confuse somebody, but you're correct. You would always, The part I've highlighted right now always gets checked. The one about the licensee probably rarely gets checked unless, the realtor or the real estate licensee is the consumer, is the buyer, is the seller. So we covered all of your questions that you had sent me, so I think we're good to go on that. Just please, please, please be aware of fair housing. Google Newsday, fair housing Long Island. Read the article and watch those videos. It will scare you to death. Doing self-inventory on fair housing. Am I treating everybody the same? Am I steering people into certain neighborhoods based on their race, their color, their national origin? Don't do that. Realtors do a pretty good job of race, color, national origin. The one that will get realtor snagged accidentally is disabilities, because realtors are trying to help people and they accidentally maybe are arguably discriminate against, say somebody in a wheelchair comes in your office and you in your mind just think, I'm just going to show one-story properties to this individual. Don't make assumptions, the saying about assume, but let the buyer say, look, I'm in a wheelchair. I want a house with a ramp that's one story. Let them be the ones to tell you that. And we've been getting a call. There was our president had an individual in a wheelchair that needed transportation to a listing, to view a listing. Be very mindful about reasonable accommodations. So maybe try to work something out. Maybe find an Uber or a government, wheelchair transport. Maybe even eat the cost. NER basically said you don't have to do it. The lawyer out in California, kind of disagreed with NER. I would err on the side of caution about reasonable accommodation on transport. And then finally wrapping up, Spanish. We do not have Spanish forms because the lawyers argue about what the English means, as you could see from some of your questions. To have another form that's in Spanish, it would never be 100% accurate translations, and the trial lawyers would use that to their advantage in a courtroom. So the best thing to use for Spanish, the buyers are going to need an attorney anyway. Go ahead and find a bilingual real estate attorney to refer them to. Maybe if you have a bilingual colleague in the office, maybe associate with them. Maybe even hire a qualified interpreter. In a pinch, what you can do if you have a smartphone, the Google Translate app, you can use the camera and point it at a document, and it will instantly translate that document into whatever language you want. Obviously not 100%, but in a pinch, you could use it to try to get by. That's kind of the main issues we're seeing. Anything you want to let us know about?
Thank you so much for your time today. Before we wrap up with Byron, terminate the care procedure during this 2 calendar days because of the restricted. They use that termination form that you said you not use unless you don't have due diligence, or you use this question. How do you terminate the care procedures?
Right. So you're never, obviously, if the only dispute is the roof is leaking and the seller says, I'm going to fix the leak. I use that because that's the only clear cut one. Anything else is subject to the seller arguing about, hey, that is an operative condition. Buyer's expert says it's not an operative condition. The seller's contractor says it is an operative condition. So only if there's a leaky roof and the seller says, I'm not going to fix that leaky roof, which probably rarely happens, could you use 313 with any kind of comfort. Everything else, I was trying to scare you guys to death. Never use 313 for repair procedure unless you also say, hey, buyer, you need to talk to your attorney because lawyers going to argue about operative condition or structurally sound. But the leaky roof is the clear-cut example. So if you had a leaky roof and the seller says, I'm not going to fix that leak, clearly you could just use it just like due diligence and terminate within that 2 calendar days. But usually people are arguing over operative condition and structurally sound, and those are lawyer arguments. So repair procedure, always in repair procedure preface, hey, yeah, the contract says you can terminate 2 calendar days. We'll use form 313 and 518 to get the earnest money. But I also have an ethical duty under Article 13 to tell you to talk to a lawyer because we're arguing over a term, operative condition or structurally sound, that experts will argue over, lawyers will argue over. And so always protect yourself on that. Now, if it's a leaky roof, inspector says roof leaks near chimney. Seller says, I'm not going to fix the leak near the chimney. It rarely happens, but if it does, you know, you could be pretty comfortable. Okay, we'll just go ahead and send the 313 and 518 to get our earnest back. I can answer. You know, there's no answer I would give. This is always. I suppose if you wanted to, you could, you know, you would, yeah, you could cite, just pull it right off the contract, pull that whole sentence off. You know, it says, you know, our inspector says, I wouldn't do it. I would just send the, you're going to, if I say you to write something in there, somebody's going to eventually make a mistake. Now, if you want to get on the phone and say, look, yeah, our expert says the septic system is not in operative condition, something like that, but telling you guys to write stuff in there is just somebody's going to get themselves in trouble because they'll take it one step too far. So I don't think that's a good idea to write it. If you want to tell the listing agent to try to, you know, be diplomatic and sell it to them, maybe verbally say, hey, our expert said the well is not in operative condition. They might say, hey, our well guy said it is in operative condition. We'll see you in court. But I would try not to write. If you want to say it, maybe. What's kind of your experience? I've never had that question before.
I just understand here with the termination procedure, it's not for termination notice, it's not for due diligence. I would think you would want to at least hear a procedure or give some explanation as to why you're sending it.
Pull that up real quick, make sure. No, I wouldn't put anything on there. It's not designed for that.
Okay.
You're just somebody. There's never an answer on any of these things that you can say always, and somebody's going to get themselves in trouble because they're going to say something that eventually somebody would send a 313, say, Byron told me I could write in there, you wouldn't paint the den, which is a cosmetic change or something like that. So if you say write it in, somebody's eventually going to go one step too far and get in trouble. So it's safest just to say no. But if you want to call and try to sell it to them, say, look, we're terminating because our radon guy says it's above EPA limits, and your seller refused to, you know, put the fans in there. Maybe if you verbalize it, even then, you know, that's just mainly for trying to sell it to them. I would just say, look, we're terminating under repair procedure. And you've already warned your buyer, so if the seller's going to sue them, you've already warned the buyer that you're, you know, get out of trouble card, saying, hey, buyer says, hey, why don't you warn me? They could sue me about saying that the well was in operative condition, saying, well, actually I did. Here's the email from, you know, March 11th when we had that, you know, when I said, hey, memorializing our conversation today about sending the 313 at your direction, but I've recommended you obtain legal counsel. That's the beauty of due diligence. You don't get into all that. You just terminate. Yeah, due diligence solves every hotline call I've ever got.